Okay, so welcome again to today's webinar. Today we'll be hearing from Legal Aid Queensland regarding their Family Advocacy and Support Services, or FASS. My name's Carly Hanson. I'm the Sector Development Officer at Community Legal Centres Queensland. And I'd firstly like to acknowledge the traditional owners of the land on which we're holding this webinar today. In Brisbane, they're the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people throughout Queensland and the country, I'd also like to pay my respects to the traditional owners of the land throughout Australia and extend a very warm welcome to any First Australians listening in today. So today we have Melissa Smalley from the Family Law team at Legal Aid Queensland, and she'll be talking to us about the Family Advocacy and Support Service that was implemented in the family law courts in Brisbane, Townsville and Cairns. So this service provides additional legal and social work support to people who have been impacted by family violence and have a current family law issue that they need assistance with. So Melissa's going to give us a bit of a summary of the service, including who it can help, how it can assist your clients, how community legal centres and others can make appropriate referrals to the service, and the impact that FASS has had so far. So today's webinar is being recorded, so if you're not able to attend the live session, you can find that on our website probably sometime tomorrow, and I'll send an email out to everyone who's registered with the link to that. We've also sent out the PowerPoints and an information sheet about FASS this morning, and they're also uploaded to the handout section of the GoToWebinar control panel just on the right-hand side of your screen. So you can download those from there if you need. So we'll take questions probably at the end of the session today. There are two ways you can ask questions. You can press the button that looks like a hand and we'll see that hand come up at our end, and we can unmute you so you can ask your question if you've got access to a microphone, or the easier method is that you can just type your question into the question box or the chat box on the control panel and we'll read that question out for Melissa to answer. We've also got two polls today, so please do pop your answer onto the screen when you see those polls appear. There'll be one towards the start of the presentation and one at the end to double check your understanding, so make sure you are paying attention. And now I'll hand over to Melissa and I'll pop back in towards the end of the presentation. Thanks, Melissa.
Thank you, Carly. Welcome, everyone. Thanks for tuning in. Yes, my name's Melissa Smalley. So I'm a lawyer in the Legal Aid Queensland Family Law team. And part of last year I spent as the project officer implementing the new Family Advocacy and Support Services to get it up and running. So the acronym that we use, as it is quite a long name, is FASS. So that's primarily the term that I'm going to be using to refer to the service today. So what we'll be covering today is how did FASS come about, who can FASS help, the people involved and what each of those people are doing, the criteria for clients to access the service, who we've been helping, and some of my own case examples, and how you can make referrals to the service. So before we get into the detail, I'd first love to know who is out there listening. So if you could just look at your screen and please select one of the options there, and then we'll just take a moment for those results to come through. Okay, wonderful, thank you. So we've got a bit of a mix there, but basically this session is going to be relevant to anyone who may have contact with someone who could be referred to the service, and we'll touch on what's required for that. But in a nutshell, it's someone who has experienced family violence and either has a very urgent legal issue, family law legal issue, or a matter in court and no legal representation. So what is the service and how did it come about? So first, a bit of background about how it all began. So basically, there was a recommendation made by National Legal Aid to the Attorney General about the need for a new service to fill a gap that was present with people experiencing family violence and having an urgent family law issue and needing assistance with that. So the model and funding was put forward by National Legal Aid and that was approved. So early last year, we needed to get the service up and running very quickly. So it is a national service, but because we were only given very basic guidelines by the government, it was up to each state to work out how they were going to implement it. There has been some discussions along the way about it at National Legal Aid meetings, but we're trying to get a more uniform approach, but so far the states seem to be operating fairly independently at this stage. So in Queensland, the service operates out of Brisbane, Townsville and Cairns. It commenced on the 27th of March 2017, so I still refer to it as a new service. I guess it's still relatively new, but it is 18 months old now and the time's gone very quickly. Initially, there was 2.5 years of funding given, so that finishes in June 2019. There have, however, been many reviews that have been taking place, and at this stage, we're very hopeful that the funding will be continued for the service into the future. So the intent behind the service is that specialist family violence and family law legal assistance would be provided to families affected by family violence who couldn't otherwise afford legal representation. So I've taken that straight from the National Legal Aid report. And for it to provide immediate legal and or support services to clients who have family law issues and have been impacted by family violence in some way. So we use quite a broad definition for that, which we'll talk about in more detail later on. The intent is also for alleged perpetrators to get assistance through the service as well, which may seem strange, but the view is that it can be better for a victim if the alleged perpetrator can also get advice. So because of this, we have at least 2 legal services involved in FASS in each of the areas where it operates, so that both parties can get that advice if required. Okay, so who can FASS help? We'll talk more about this, but just to give you a bit of an overview, FASS can essentially help in 2 situations. But first of all, the client must have been affected by family violence in some way, okay? And we'll talk more about how we assess that, but that must be present in order for the client to be accessing the service. Other than that, it can help clients in one of 2 ways. The first is if the client has a matter in the family law courts, then on that day they can get assistance. So that is similar to our current family law duty lawyer service, but we also have a support worker or social worker now available to clients, and the lawyers can now generally give some more assistance than they would under the general family law duty lawyer model for clients. The second circumstance is if clients are requiring urgent legal assistance. So that's in a situation where action needs to be taken immediately or just as a general guide within about 72 hours. And it's matters such as the recoveries and the airport watch list matters. And the whole idea is that it's filling the gap between a client being able to get legal aid or see a private lawyer or go to a community legal centre, because we know that those things all take time and sometimes there just isn't the time available. So it's certainly not intended to take the place of legal aid grants of aid or for clients to go and see a private lawyer if they have the means to do so. And so as part of the service that we would give clients is we'd usually complete a legal aid application with the client as well, if it was appropriate when the FASS assistance is being given. To give them that ongoing assistance, which FASS doesn't cover, it really is intended to be an in and out service, addressing the urgent issue at that time. Okay, so with the service, there's no formal means or merit test, but we have parameters given funding, and sometimes we do have to prioritise who we're going to help on the day. It's a face-to-face service provided at the time the client attends. There's no bookings taken. There's also no means for telephone or video interviews to take place. However, I'd really hope that that would be reviewed and perhaps looked at in the future. Both legal and support services are available if necessary for both parties in the dispute. So that's the conflict service that I referred to earlier. So who are the staff involved for the service? So we have an intake officer, a duty lawyer, and a social support worker. So our social support workers are usually qualified social workers. However, the term that we were given from government to use was support worker rather than social worker. So in Brisbane, the services that we have involved in providing the FASS is primarily Legal Aid Queensland. So they have the intake officer, also a lawyer and a support worker. And in Brisbane, our conflict service is Caxton Legal Centre. They have a FASS lawyer and support worker, and we operate out of the family law courts in Brisbane. In Townsville, we have a Legal Aid Queensland lawyer. North Queensland Women's Legal Service provides legal services. The Townsville Community Legal Service, again a lawyer, and the North Queensland Domestic Violence Resource Centre has the support workers available. And then in Cairns, Legal Aid Queensland for a lawyer, North Queensland Women's Legal Service, again for a lawyer, Cairns Community Legal Centre for a lawyer, and the support work comes from the Cairns Domestic Violence Service. So what do each of these people do in their roles involved in FASS? So for a duty lawyer, if a client is in court that day with no lawyer and they've experienced family violence, so they fall within the FASS category, then the assistance they're giving is generally similar to the family law duty lawyer service, which already is in existence, except they're more likely to qualify for a bit of extra assistance. So at an absolute minimum, we're providing advice to that client. In some situations, it may be that we prepare some basic documents for them if it's appropriate and we're able to. There's more representation given than general family law duty lawyer clients. However, that's still very limited, and I'll talk about that. And we're also ensuring that legal aid applications are completed where it's appropriate. What I'm really wanting to stress here is please do not tell clients that we represent them in court when they're attending either for FASS or just general family law duty lawyer, because it can really lead to a very upset and anxious client if they're there and that's what their expectation is and that expectation isn't met. And this can become very difficult at the moment because we have the DV duty lawyer service, and in the majority of those cases, clients are being represented. So they see that that same thing should be happening, but it's just a very different way of operating in the family law courts, and it's just not possible for us to be able to act for every client, and also not always in their best interest, which I'll speak a little bit about as well. But it really does depend on the situation and how busy the service is. Also, no matter how vulnerable the client is, there are certain types of matters that we can simply not appear in. And they're things such as complex contested interim hearings, contraventions, enforcements, trials, etc. So with appearances, if it is to happen, it's usually in very special circumstances, and it's more for those basic matters such as an adjournment application, a mention, consent order, simple interim matter with special circumstances. And document preparation, we're looking at things such as maybe a minute of order sought if they haven't been able to file any material yet, a very basic affidavit if that's felt that that's necessary, and maybe notice of address for service, basically things like that, but it's certainly not full sets of documents or detailed documents. So I thought I'd just give you an example of a very recent case I had in which I did some document preparation for a client. So to give you a bit of a background, my client was 21 years of age. She had 4 children, 1 newborn. The first 2 children, she believed the father was her uncle, as there had been sexual abuse happening from a young age. The father of the 3rd child was known, but appeared to have many different issues. And the father of the 4th child was a convicted pedophile and also seemed to be her mother's partner. So the client had many issues. She'd had difficulties with drugs and not being able to provide for the needs of the client. She'd been in violent relationships and had DVOs against some previous female partners. So the Department of Child Safety had been involved last year. They'd given the 3 children to the maternal grandfather and the maternal great-grandmother, who they lived together under a short-term safety plan. But the mother was able to get herself together and then tried to get the kids back. They refused. So earlier this year, she went to the daycare centre and took the youngest of the 3 children, who's 3 years of age, and they had been with her for about 5 months. So the maternal grandfather and the great maternal grandmother brought the application seeking for that 3-year-old child to be returned to them and for all 3 children to live with them. They weren't seeking orders about the newborn. The mother had only been served 1.5 weeks ago. She'd filed no response documents, but to her credit, to court, she had brought along a lot of documents with her. So these were things such as support letters from the daycare centre, support letter from the Department of Child Safety, case plan for her young baby showing the supports that were in place for her. And there was also some incident reports from the daycare centre, as the other party had been alleging that she had beat this 3-year-old child because he had a black eye at one stage, etc. But that was actually caused by incidents at daycare, which could have been shown by through these documents. So I felt it was very necessary to get those documents before the judge, and I also felt it was highly unlikely, given the situation, that the judge would just be adjourning it off to give her time to file whatever documents that she needed to, and would at least want to look at the matter on an urgent basis that day. So I prepared a very brief affidavit annexing all those important documents and also briefly outlining her position in the affidavit so that she had something to provide to the judge, and obviously also gave that to the other party's solicitors. We tried to negotiate some orders for the interim, but we weren't successful. Both parties wanted all 3 children to live with them. So this was a case where, even though the client was highly vulnerable, she represented herself in court, as it was a contested interim matter. It was complex with a history which I just could not get my head around and didn't have the time to be able to understand. But of course, we try and help the clients in that situation. So I was really trying to empower her, telling her that she knew everything about her case. She was the best person to speak to the judge about her children, giving her general tips to take deep breaths and just think, I'm doing this for my children, I'm here for my children. But really, in those circumstances, they do know the case so well, and they often do get great outcomes because they also bring that emotion and that realness of the situation to the courtroom. And that can be incredibly persuasive to a judge. So I generally tell them not to worry if they're crying or anything like that, and just to be themselves. But I thought I'd just mention that so that it can give you a little bit of insight into what we do in the service, and also a situation in which some basic document preparation may be provided, but also no representation being given despite a highly vulnerable client. And also just highlighting that some people seem to think that the best outcome will always come from having a lawyer represent them. And that really isn't always the case. And there's been a few times for me personally where I've been representing a client and I've really just felt like I've been inhibiting their case, because there's things that I'm being asked to respond to that I just don't have the answers to, and I'm forever having to go to the client and try and get these responses. And also, yeah, if you're not across the case, and you also just don't bring that emotion to the case. So, yeah, we'll obviously do it when it is absolutely needed. That's part of the service, but it's just understanding that it's not in every situation that we will represent clients. Because there's also issues with us having other demands on us, and the delays which that can cause if we're having to hang around a court to represent a client, and then the time of waiting in the back of the court, and then the time of representing the client and explaining things, etc. And we also don't want an expectation that people have that they can turn up without having gone through the process of being approved for legal aid to get a lawyer, or getting a private lawyer and have someone represent them. But of course, we'll do it when we need to. So to give you an idea of when representation might be given, the last case I appeared on was for an interim consent order before Judge Jarrett. So there was a young child, 2 years old, never met the father, very severe domestic violence in the relationship. They'd reached a consent order for some time at a contact centre. The mother had been diagnosed with post-traumatic stress disorder because of the family violence, and she was just a shaking wreck at court, and she was very worried that she was going to have a panic attack in the court. So I appeared for the client to hand out that consent order, and I was very glad that I did, because Judge Jarrett was challenging the order and wasn't in the best mood at the time. Afterwards, my client told me that she actually felt very sorry for me in court, so that may give you an indication of how it went. But I just thought I'd give that to you as an example that certainly that was a matter in which representation was absolutely needed, and that we will step up and do that wherever we can. Okay, so that was a long explanation, but hopefully gave you a bit of insight. So what do the duty lawyers do for those matters that aren't in court? So these are the very urgent legal issues, and we'll talk more about that definition. So at an absolute minimum, we're looking at providing them advice. For recovery orders, if it's appropriate in the situation, we may phone the other party. My experience is that generally the phone's turned off and I can't get through, but sometimes you can, and just be saying, look, we're trying to assist this person, when can you return the child, and see if they'll negotiate it by phone. We can also do letters for return the child if we feel it's appropriate, and we can also do a simple court document preparation, but of course that's limited as well. But that can be up to a full set of court documents for an application for a recovery or an airport watch list in extremely urgent cases and where the lawyer has the time to complete the documents. But if that is the case, and if we're drafting documents to get the case on, it is basic documents, and it's also only addressing the urgent issue. We're not addressing any of the future matters that the court may need to deal with. But again, my request would be to please not tell clients that they can come to us and that we will get all their court documents done for them. Once again, it really depends on the situation, and it's discretionary with the lawyers in terms of the urgency and also the other demands of the service. Okay, so we now have support workers with us, which is something which is very new. And for the lawyers involved in the service, it did take a little bit of getting used to working with support workers. But they have been wonderful in helping clients. And it really does help from a lawyer's perspective, because before we were having to worry about everything. And we weren't just being the lawyer, we were being the counsellor and the social worker and the psychologist and doing whatever we could to help that client in many other ways. Whereas now we're really able to focus more on the legal issues, and that support worker takes on a lot of that work and does a wonderful job. But to give you an idea of what they're doing, it's things such as risk assessments, safety planning, if really necessary at the time. Otherwise, we'd refer them to other services which are more appropriate for them to complete. Lots of referrals, counselling, but that's on the day, not on an ongoing basis. Information about applying for a protection order and legal aid applications. So, of course, it's very important to respect the support services that clients may already be connected with, and we don't want to interfere there. But quite often the role will be for the support worker to be an emotional support and strength for the client on that day, and also give them the referrals that are needed. But they can also be an advocate in relation to other things, such as with police and getting action taken with protection orders and things if that's needed. So there are a few things outside of that which they can do. Okay, so going back to the criteria to access the service. So if you remember, we're talking about those two different ways in which the client would meet the criteria to access the service. So the first is that there's either been impacted by family violence plus the very urgent legal issue, or impacted by family violence plus has a matter in the family law courts that day, which is the one where it's similar to the family law duty lawyer service, with extra support being given. So how do we assess family violence? So from my understanding, there's different assessments that are happening state to state. When I first started as a project officer, I was trying to come up with a way in which we could assess it here in Queensland. What I came up with at that time was a list of 8 questions, which we then incorporated as part of our intake form. And if the client was able to tick yes to 2 or more of those questions, then we'd say that it meets the family violence criteria. So just to give you an idea of the types of things that those questions are, they're things such as, has anyone involved in your case ever threatened to kill or harm you or your children? Is there a current domestic violence protection order? Are you unable to make your own decisions about your case because you feel controlled by another person involved? So I've tried to cover all the areas of family violence, and there's no time frame, so it can be historical. But we've also found those questions very helpful because it gives you a snapshot in looking at the form of knowing the level of what's going on at that time. And one of the first questions is, are you fearful of your safety while you're at court, and do you have a safety plan? So that's been very helpful in us being able to look at that and know where things are at and see what immediate support that client may need. And it also helps us to then know what questions we may need to ask that client. So that's what we started with. It is, however, being reviewed and likely to change, but that's our current assessment, just to give you an idea. But certainly if the client's talking to you about family violence that they've experienced and you're getting the feeling like, yes, this client has experienced family violence, then they're likely to meet that criteria. As I said, it's quite broad. And it's not intended to be excluding people. And again, it can be for anyone who's been impacted, grandparents or anyone else. Okay, so that's the family violence criteria and what we're looking at there. So what are we talking about in terms of the very urgent legal issue? So refer back to what we talked about earlier. So this is filling the gap between them being able to get other assistance, getting a legal aid grant, seeing community legal centre, seeing a private lawyer to get their situation sorted. So we're saying it's too urgent for that. It can't wait for that. We need to have this intervention before all of that happens. So the majority of cases that we see are recoveries where there's risk to children. We also do airport watch list matters where there's imminent departure, or we don't know when the departure is, but there seems to be some red flags there that something's happening. There may also be circumstances where we may get involved in property matters or some urgent injunctions. I'm unaware of any, well, I certainly haven't done any myself, drafting court documents. Maybe situations where we're at least able to give some urgent advice, which helps that client to preserve assets or things like that, where they'd otherwise have to wait a few days to get that advice, and that may take too long. But yeah, it's looking at what is very urgent. Now, attached to the it might have been emailed to you, or it's attached to the handouts there, as well as the PowerPoint. There's also a 2-page PDF document titled The Family Advocacy and Support Services, Information for Service Providers. So this was a flyer that I did up very quickly last year that was posted out to the community legal centres and domestic violence services last year with a letter advising them about FASS starting. It hasn't been updated since that time, so there's a little bit of information about referrals, which probably isn't the best way to go now, but we'll talk more about referrals later. But on the second page is a list of examples of very urgent legal issues, which you may find handy in making an assessment on this. I'll go through it quickly, but hopefully you'll notice that the bar is set quite high in terms of what we would consider as very urgent. And can I just say, it's usually those matters that you just get that gut feeling of, oh dear, like this is a really awful situation or something really bad is going to be happening, and this client needs help right now. This cannot wait. And you get a bit of a panic as to where you send the client and how they can get the help that they need. So just bear that in mind, that if you're getting any of those feelings, then certainly remember FASS and perhaps refer to this guide and follow the referral process that we'll talk about. So this is just to give you an idea. So the top examples, so that's for airport watch list matters. So it's a child is about to be taken overseas without a parent's consent, particularly in situations where they have access to a document to be able to travel, passport or travel document. Person's leaving the country within the next 72 hours, or we don't know when they're leaving, but it seems as though something's definitely happening. The person taking the child has connections to overseas countries. The person taking the child could intend to permanently relocate them. And the child is being taken to a non-Hague Convention country. So it certainly doesn't have to meet all of those criteria, but they're just some little red flags to bear in mind, and they would usually lead to the matter being considered very urgent. In terms of recovery, that's what the second set of information is dealing with. So there it says the child has just been taken from their primary carer. The other person will not return the child, and there is a risk of harm and concerns for the child's safety and well-being due to factors such as, and they're the general things that we see with the risk of harm: drug use, excessive alcohol use, untreated or severe mental health issues, family violence, including previous harm to a child, disability, which means that they can't care for the child safety involvement, history of violence or sexual offences. Child's very young, so under 2, and that's just a guide. It's not a rule that we enforce strictly, but to give an idea, and they're solely reliant on a carer meeting their basic needs. or the child has a disability or special condition, and the person who has the child isn't able to meet that. So once again, they're just some flags that you can consider in terms of looking at risk of harm and urgency of a case. Okay, so who have we been helping? So I just thought I'd give you a few of my own personal case examples. So I'm the allocated FASS lawyer in Brisbane 1 day per fortnight, and these are just a few of the matters that I've had, but of course there's been many more that I've had and also my colleagues have had. But just to make it real for you and to give you an idea of what we're doing and how we're helping people, I'll go through a few examples. So the first one I wanted to share in some detail about this case because it hopefully shows the great things that can be accomplished through this service. So this is a newborn baby case. So my client was an 18-year-old mother of a 9-week-old baby. The basic facts of the case were that the parties had been together for about 1 year. Client fell pregnant soon after they'd started the relationship. There was severe family violence during the relationship, and the mother had actually been hospitalised a number of times due to injuries, including for a broken nose during pregnancy. The police had applied for a protection order on her behalf after one of those incidents. However, it was only the standard conditions as the parties were still together. The father had not been charged with any breaches of the protection order though, despite further hospitalisations taking place after the protection order was in place. So the event which led to our client coming to us for assistance was that the father had attended her home, had physically assaulted her, punched her numerous times, and then had taken the 9-week-old baby and run off down the street to his car. So the mother had taken photos of the severe bruises to her body and a cut on her neck from the assault. And from the mother's instructions, there were a lot of concerns about this little baby's safety. So the father, on her instructions, had untreated bipolar and schizophrenia. He'd also used illicit drugs frequently, including ice. He had a very violent history, including many criminal convictions for things such as assault. And he was not involved in the care of the baby and wouldn't be able to meet the baby's needs. So as you can imagine, it's a really, really awful situation. Definitely one of those matters where you'd be getting those feelings of, oh my goodness, what can be done here to help her? So what she did was she sought the help from police. They told her that she needed to go and see a lawyer and they couldn't help her. So she attended at a preferred suppliers office in Hervey Bay and completed a legal aid application. The preferred supplier, however, identified it as being extremely urgent and encouraged the client to make her own way to the Brisbane Federal Circuit Court and make her own application for an urgent recovery order. So the next day, early in the morning, she took that advice and she travelled to Brisbane and she attended the registry to try and get the court documents to do up the application herself. So the registry staff, who have been trained, identified the matter as very urgent. They then referred it to FASS. The intake officer assessed the matter as being FASS appropriate, so urgency and family violence. So then the client was seen by myself and a support worker. So the client was obviously very distressed. So the support worker provided the emotional support to the client throughout the interview process and discussed the family violence and options available to the client and gave numerous referrals for her to get assistance and support. So I provided the client with the legal advice. I also drafted all of the necessary court documents to apply for a recovery order. As part of completing those court documents, we needed a copy of the protection order. So during the course of the time we had together, both myself and the support worker had been speaking to police We were trying to get some documents for them to send through, which they did. They emailed through a copy of the current protection order. They also provided the QP number for the most recent call out. I think it was about 3 days prior, which was included in the client's affidavit. I also discussed with the police what action they were taking after the most recent incident of family violence and if they were going to be charging the father with breach. And I also made some strong recommendations that they vary the client's domestic violence order with extra conditions. So we put in a plan in place for the client to attend the police station when she returned, and she was to complete a witness statement, and then they were going to consider this further action. So what happened from there was we completed all the documents. I ran downstairs to the registry, told them it was urgent, got it looked at by the registrar. The matter was then listed in court on an urgent basis before a judge 20 minutes after I'd filed it. The judge made the recovery order on an ex parte basis. The client then returned to Hervey Bay. This was in the afternoon, and then that night she had the child returned to her. So I actually phoned her a few days later, and which isn't always done. We don't always follow up. We just deal with the urgency. But I did follow up with her. There was some information I needed from her, but she did advise that, yeah, the baby was returned that night. Her legal aid application had been approved, so she now had a lawyer representing her for the case moving forward. She had also completed her statement with the police, and they'd advised her that they'll be charging the father with breach of protection order, and they were applying for a variation of the order on her behalf and adding extra conditions for her safety. So hopefully that gives you a bit of an idea of what FASS can do for clients in that situation. And for her, it was a really great outcome. And she had travelled a long way, and ideally we wouldn't be having clients in a distressed state having to travel, but she was already there, and the registry staff had picked that up and sent it to us. But we were able to get that recovery order sorted within that day. And I can just imagine if the service wasn't there, then she would have been sitting in that registry in a complete distressed emotional state with these court documents in front of her, numerous documents to complete, not knowing where to start, and having to do that on her own. And then whether or not she would have been able to do enough to get an urgent listing of her matter, and whether she might have had to stay overnight in Brisbane and all the issues that creates. So it was just a great example of how FASS was able to help her with the legal side of things, but also promote her safety and advocate for her with the police to get the protection order looked at and the father charged with breach. So just a few other examples. I won't go into in as much detail, but just to give you an idea, a couple of weeks after that matter, I had a 5-week-old breastfed baby. What had happened there, the parents had already split. There was severe family violence in the relationship. But the father and the paternal grandmother really wanted to take the child for 1 hour to go and see the great paternal grandfather. Because there was some restriction around it. It was only going to be like a one-off opportunity to be able to see him. Mum was very hesitant. However, she said, okay, if it's just for 1 hour, but my older brother needs to go with you. So the three of them left, and they went and saw this great paternal grandfather. However, as they were leaving, Dad did a runner, and he just bolted down the street with this 5-week-old breastfed baby, and then he couldn't be found. So, yeah, that client through, I can't remember, I think it was another registry referral, made her way to me. We're able to get her all the support that she needed, and had the recovery order listed that day because she got there early enough in the day for us to help her, and the baby was returned that night. Another one, the father was on ice. This was one where the parties were still together. He was on ice and had had been controlling her for about 48 hours, kept her trapped in a room. She wasn't able to leave or anywhere he went. For example, if he went to the bathroom, she had to come with him. They had a little newborn baby and a 1-year-old, and he just, wouldn't let her sleep, was just screaming in her face the entire time for this 48-hour period. And eventually there was a situation where they were in the bathroom and the newborn had just been crying excessively, just screaming her head off, and she somehow managed to get the father to agree for her just to go out and pick up the baby and come back. So she was able to grab her wallet and keys, grab the 2 kids and bolt to the car. So she took off towards her mother's home. He had followed her, guessed where she was going. She had to pull in and get some fuel, and he pulled into the service station as well and saw her. He got in the car, punched her in the head numerous times, grabbed the 1-year-old from the back of the car, threw the 1-year-old in his car that was there and took off. And then he proceeded to send her a number of photos of the child in a distressed state, with a cut to the child's forehead, the child sleeping that night on grass in an open area outside with a little blanket on him. It looked like he'd been crying, saying, he needs you, you have to come back, trying to control her and get her back into the relationship. So she came to us, and again, it was another situation where we were able to help her and give her the support that she needed, the referrals that she needed, get a protection order, help her to get a protection order applied for and get the child back, which happened very quickly. And another one as well, which you can just read there, the father broke into the mother's house in the middle of the night, forced her to have sex and took the 1-year-old who very barely knew. So again, that's just a few examples, but there's many others and the things in which we're helping with. I won't go into them in detail because, sorry, I didn't have that on the right slide. But here I've just listed a few things that aren't considered urgent. I'm not going to go into them in detail. But what I will say is it's generally those matters where the parent who has the child is having no time or supervised time or limited time, and then they've suddenly taken off with the child and there's some risks. And it would definitely qualify for an exemption from FDR on the basis of urgency. Okay, so how many people has FASS helped so far? So these are the latest figures that we have. So this was for the first 12 months. We had helped 939 clients had seen a lawyer and 236 had seen a support worker. And we expect the support worker numbers to increase now because we've changed our approach and the lawyers are now working collaboratively with the support workers instead of referring them to support workers only if needed after the lawyers finish with them. I also don't have exact figures, but the last time I did calculations, it was about 40% of our figures were the very urgent matters not in court. So to give you an idea, it's roughly 1 a day or a bit more, which, some days there's none, some days there's 3, but there certainly are those extremely urgent legal issues out there. So then there'd be other 60% as the matters in court. So we do have another poll just to ensure that you're there, and that is what percentage of clients that FASS has helped do you think would be male? So if you can just have a look at your screens again and just hit one of those responses. So we've got 10%, 20%, 30% or 40%. Okay, so the majority of people say that it would be, no, sorry, maybe getting a bit premature there. Okay, so 40% of people, which was the majority, thought it would be 40%. Interesting. Okay. So it's actually 30%. So about 300 male clients were seen by FASS lawyers. So we know that males can be domestic violence victims, but also for the others, it goes back to that intention mentioned where it's best if the victim and the alleged perpetrator can get advice. So where do our clients come from? I've listed all the different places. So court registry, who have trained throughout legal aid and the different ways in which clients come in contact with us, community legal centres and domestic violence services. So how can you refer clients to the service? If they have a matter that's going to be in court, then on that day you can refer them to go to you would usually to the family law duty lawyer service. So we have the same intake officer. So you'd usually refer them to the Brisbane courts, the intake officer and level 1. So you can still do that. However, if it's a really complex matter that's in court and you're wanting to give copies of court documents or give a history and you don't think the client will be able to give instructions in a way which will help that lawyer to best help them, then there are other referral ways which you can use, which we'll look at next. But if the matter's not in court, then you're looking at FASS and you're making those assessments. So referring clients in Brisbane, so you can call legal aid on the 1300 number. Otherwise, we're now telling people that they can contact the principal lawyers of our family law team. So that's Sue Ellen and Sarah. They're currently responsible for the running of FASS in Brisbane and can ensure that it is an appropriate referral. We also have a FASS email address. So that's the email where you can send information for conflict checks or send documents once it's been approved. The process generally is at the moment that if you're looking at making a FASS referral, then first we're doing the conflict check to see if it's something that we can help with, or for example in Brisbane, whether or not it needs to be referred to Caxton. And then after we've done the conflict and that's okay, then you can provide those details and we can look at whether or not it's FASS appropriate or whether or not there's a better way to support that client and get them the help that they need. Then for Cairns and Townsville, the best way at the moment is just to contact their legal aid officers. Their front counter staff are trained in FASS and have their own processes in place, and they also have their own FASS emails as well if it's appropriate for you to send through documents to them. But yeah, we definitely don't want you just sending off clients to court to try and find us. It's not the way in which it's intended to happen. So yeah, please phone ahead and see if it's something that we may be able to help with. And for matters that may not be a FASS appropriate, then it's your usual for referrals for urgent advice and possibly an urgent legal aid application. And just to finish on, a few practical tips when you're making referrals for clients. So to really think about the client's location and situation, I mentioned before that's really not ideal or safe to have clients travel long distances in distressed states. That's problematic because people often need this help and it's only available in 3 locations in Queensland. However, we really just have to think about what may be best for that client in that situation. Clients to bring along documents if they can. We know that in those extremely urgent situations that's difficult, but particularly if they have a matter in court, please bring all their documents with them. Not having children attend, obviously, or having someone there to arrange to watch the children. With our very urgent legal issues, of course, there's maybe exceptions sometimes if it's a newborn baby or something, but generally we won't see clients with children there. And it can take some time for us to help them, so it just doesn't work. Please do not refer clients to attend late in the day. If you've got the okay to refer them to FASS and if they're coming the next day, stress, please, that they are to be there at 9 a.m. The earlier the better, because we have so many demands and we don't want to waste time. Recently, I had a client that was referred to FASS. However, she had a DV mention that morning at the Gold Coast. and had to deal with that first. And then she didn't drive. She had to wait for a friend to be able to drive her to Brisbane to see us. She didn't arrive till 3:15 p.m. By then it was just a complete waste of time for everyone. The poor thing was so distressed and flustered. Not much could be done. She wasn't going to be able to come back to us because she couldn't drive and was relying on a friend taking work off and everything else. So we just did an urgent legal aid application, got it approved the next day for her to see a preferred supplier in Gold Coast, and that was the best that we could do for that client. And just wanted to, they can be at court for a long time, so eat beforehand, bring snacks and food if they can, be prepared for a long day. And also just wanted to mention as well is, again, the intention is that we will, for people where it's appropriate, we will get them a legal aid grant of aid. However, we see many people falling through the cracks because they just don't have the financial documents to support the legal aid application. So I thought I'd just highlight that if clients are wanting to apply for legal aid, to try and get them prepared with the documents they need. So that's the Centrelink statements, or if they're working, the pay slips for the last 4 weeks, and the bank statement for the last 3 months. And if possible, if they can bring those, and that's a huge help because we want to make sure that those that need that support get it, and they're not falling through the cracks just because they can't get those financial documents. And sorry, haven't left much time for questions, but hopefully you found that helpful, and hopefully it's covered many of the questions that you may have had previously. But if you do have questions, then feel free to send them through and we'll try and deal with those.
Thanks so much, Melissa. Just a reminder that there are 2 ways you can ask questions. So you can press the button that looks like a hand if you've got access to a microphone, or you can just type your question into the question box. So there has been one question that's come through so far from Sophie. So Sophie, your question is, do the clients go to the registry? Is there a cut-off time?
Okay. So with going to the registry, no, some of our clients are referred by the registry to us. We're located on level 1. However, I stress that you're not to send clients straight to the court. And if you've spoken to someone beforehand and they've said, yes, it's okay to refer them to FASS, then they will take you through the exact information of where that client needs to go. So yeah, you'll be provided with all that information if it is an appropriate FASS referral. Is there a cut-off time? Well, our service only works until 4 p.m, but we say the earlier the better because we have so many demands on the service, and particularly for those matters where we may be doing a full set of court documents, that takes hours. So they need to be there as early as possible.
Thanks. Hopefully that's answered your question, Sophie. I've got another question from Chrissy. What sort of property issues might your service assist with urgently?
Okay, good question. I wish that I brought my service parameters that I did up at the beginning when we're looking at what we would help with, what we wouldn't, but I don't have that with me. It would have to be incredibly urgent, and it would usually be a property injunction that needed to happen because something was going to happen that couldn't be reversed. Yeah, as I said, I haven't really come across a case in which I've been minded to draft any documents or anything of that nature. Would usually just be giving some advice, if they're really concerned that the house is about to be sold or whatever it is. Then we may give them some advice about what their options may be for that, or if this lump sum of money is about to be taken or whatever it is. So yeah, it would have to be something incredibly urgent, because otherwise they'd be able to get that support, hopefully, through other ways of getting advice. Sorry, I should have brought that document and I would have been able to give you some exact examples, but I just can't think off the top of my head right now.
That's totally fine. They might be able to access that information elsewhere. Would that be the case? Or
probably not.
No,
it's an internal document.
Available.
No.
That's okay. Okay, so if there's any last questions coming through, I'll just give you a couple more moments to send those over. Did you want to pop the office locations up on the screen as well for legal aid while that's
Yeah, sure. So that's all of our legal aid offices. However, the ones in which FASS is operating, of course, is Cairns, Townsville and Brisbane. And also that's our legal aid contact numbers. And so, for example, if you were wanting to look at making a FASS referral and you didn't have this PowerPoint on you with Sue Ellen and Sarah's phone numbers, then you still, of course, could phone the 1300 number and let them know that you think you have a client that may need to come to FASS. And they, of course, are trained as well as to the way in which they'd go about dealing with that call and ensuring that it's FASS appropriate and approval is given for that client to be sent to us.
And so, Melissa, all these numbers on the screen, are they publicly available for clients to call as well?
Yes, yeah. Absolutely.
Fantastic. Okay, it seems like that might be all the questions. I think because Melissa's done such a comprehensive presentation, hopefully it's just covered everything that you need to know about FASS. So on behalf of everyone who's listening today, thank you so much for coming along and presenting about the FASS program. It sounds like a great program, and certainly I hope that all of our CLCs who are tuned in now have a really good idea of how to make appropriate referrals for clients who might have those urgent matters in the family court. So thanks so much for coming along.
Thank you.
And for those who are listening, I'll be sending out a link to the recording hopefully later this afternoon or tomorrow, so keep an eye on your emails for that. I'll also be sending out a link to provide some feedback, so it'd be great if you could fill that one out as well. So hopefully we'll see you at our next webinar. Thanks so much, everyone, again. Have a great day.